See if anybody pops in here. We're gonna go over this mail that I got today. It's an objection, which is pretty standard. It's an objection to the motion that I filed. We're gonna go over that. So, what's going on? How's everybody going? Oh, let's see. Say what's up in the chat. And definitely another thing, check the description. This is a pretty serious situation that I got cooking here. Let me make sure all these notifications, shut those off. All right. So hey, yo, what's up? Keeping the swine in line. That's what we're doing here. So yeah, we got a situation with this phone, right? The phone theft. And they're claiming that they got a warrant, and I'll speculate on that after I read this. Again, people have been asking different ways to support and everything like that. I don't like asking for donations, so for many months I've been building out a shop. It's a print on demand shop with some gear, right? And I'll show you. I got some for myself. This is one of the embroidered, call it the Revolution hoodie, because it's got Absolute Defiance in a circle there. It's got some embroidery on the wrist. This is the brand that I came up with, Boogaloo Zoo. And then on the other sleeve, of course, we got the old FAFO. And there's a bunch of stuff. There's hats, bunch of hoodies. I got one of these hockey jerseys. It's a hockey jersey. It's got Absolute Defiance across the chest. It's got a gigantic FAFO on the back. It's got FAFO on the inside here. Do I look like I give a fuck? That's what that is, the acronym right there. Do I look like I give a fuck? And on the sleeve, my quote here, I speak with my feet. So I got this. This is when you want. Oh, and then the sleeves, the other sleeves got flames, flaming towards whoever you're throwing your arms at. So that's for if you want to make a loud statement. Some of the designs are more subdued. I did everything myself. I spent, like I said, many months building that site out. And really the best way is the Lion's Den, okay, which you sign up through GiveButter. It's $5 a month. I'll send you a one-time join link for the private Telegram group, and we got all these different topic chats for everything you can think of, and we can make all kinds more. And that's the easiest way for like-minded people like us to network and support each other. So yeah, it's $5 a month. Sign up through the GiveButter. I'll get the email. I'll send you an email with the one-time link, and I'm going to be giving people a discount in the shop who are members of the Lion's Den as well. So get in there, get active, show your support. We got bumper stickers in there in the shop as well. So I'll stop with all that. So I got this today in the mail. This is the government's objection to the motion for reconsideration, okay? Because there's technically not a motion for reconsideration. I don't know what they called it. That's what I called it, but I formatted my thing right off of their rules. So there is 100% a motion for reconsideration, right? He says, the defendant was convicted of the petty offense of failure to comply with and follow law enforcement orders in violation of 41 CFR 102.74.385 after a bench trial on April 9th, 2024. He was sentenced to the minimum fine of $100 and a mandatory processing fee of $30. Judgment was entered on April 10th. On April 24th, the defendant filed a motion for reconsideration. As a procedural matter, neither the federal rules of criminal procedure nor statutes provide for motions for reconsideration of judgment. The normal course of for a criminal defending Defendant challenging a judgment is an appeal, and the court advised the defendant of his appellate rights during the imposition of the sentence. It's more than 14 days have passed since the entry of judgment. Time for appeal has elapsed. No. So this resets the 14 days because I also asked for a new trial under Rule 33. Even if the motion were procedurally sound, this is the thing you got to be careful of. With any time the prosecution files a document, they're going to try to make it sound, very hardcore and legit. And most of the times they're not. They take case law and they cite it out of context and not on point. So this is the prosecution here. He says, even if the motion were procedurally sound and the court should still deny it on its merits. Some courts have permitted motions for reconsideration. See, he admits it right there. Some courts have permitted motions for reconsideration in criminal cases for matters other than a judgment, but they have followed the legal standard for the in Federal Rule of Civil Procedure 59E, considering motion for reconsideration on ruling motions in limine. 59E, relief is granted sparingly, and that says civil procedure. I don't know why he's quoting civil stuff. When the original judgment, evidence manifest, yeah. So if there's a manifest error of law, which is what I claimed, and if there's newly discovered evidence or in other narrow situations, and I believe this whole thing is pretty narrow. Construed liberally, the defendant's motion relies on the manifest error law prong. See, he reiterates his position from trial under New Hampshire RSA 123.1. And he says the Rudman Courthouse is not federal property because New Hampshire never ceded the property to the federal government. Correct. Specifically, he contends that the federal government never made a filing with the New Hampshire Secretary of State's office describing the land on which the courthouse was built. Correct. However, compliance with RSA 123.1 is irrelevant, as New Hampshire is not asserting that the Rudman Courthouse is state property. We don't have to assert. The law defines it. And even if the state was claiming so, the Supremacy Clause plainly invalidates state laws that interfere with federal law. And that's not true, because even if they did have jurisdiction, it's concurrent jurisdiction with New Hampshire laws. So there's no interference with anything. They're the ones interfering here in New Hampshire. In any event, there is no doubt that the Rudman State's Courthouse is, in fact, federal property. Blah, blah, blah. The federal building, as its name would suggest, is federal property. Blah, blah, blah. Courthouse, to the extent that defendant is arguing that federal courthouse is not federal property, the argument finds no support in common sense, ordinary understandings of property. He didn't address any of the Major Douglas Air Force article that defines and distinguishes all the different types of jurisdiction and ownership of property in cession, and this is one of the main ones. They can purchase and they can acquire through cession, and they've provided no documentation of purchase, and they've provided no documentation of cession. I've provided documentation counter to, proving that there never was a cession. So there can never be a secession. The secession movement here in New Hampshire is basically dead. So there's two more paragraphs here. Separately, the defendant requests that the court issue a written decision on the merits with findings of facts and rulings of law. Of course, under Federal Rules of Criminal Procedure 32 and 35, the rules do not require the court to issue a written order where, as here, the court articulated its reasoning for its verdict on the trial record. And there's a footnote. And so the footnote says the defendant is free to purchase a copy of the transcript. So they're telling me that she articulated herself on the record, and she did not articulate herself. Okay. So the proper thing is to write down the findings of fact, what I did, and, what elements were proven, how they were proven, and all that, just in the decision, right? And that way I can appeal it based just off of the legal rationale instead of having to get a transcript of the entire proceedings and have to pay for it. This is another reason why they don't want us to record, and that's why I was doing exactly what I did, is because they want you to pay for the transcript. That's all it is. They don't want you to be able to document and produce your own record and save the hundreds of dollars, because the transcript is not cheap. The transcript is actually thousands of dollars typically. So that's ridiculous. Last paragraph. Oh no. And in any event, because this was a petty offense for which the court announced it would not impose a sentence of imprisonment, compliance with the federal rules was discretionary. So they don't have to follow their own rules when they say they're not going to send you to prison or jail. It's discretionary for them to follow the rules. If they're going to deny you the right to a jury trial and right to counsel because they say, well, we're not going to send you to jail one way or the other, so we're not going to give you any of your rights. Finally, the defendant claims that a witness stole his phone in court. He did. He was a witness, and he stole my phone. During the imposition of sentence, the defendant took out his phone and appeared to begin recording the court, despite being repeatedly warned that doing so was a violation of rules and that the defendant risked being found in contempt. Risked being found in contempt. I wasn't found in contempt. There was no contempt. You guys saw the call with the clerk. There is no contempt on record. Law enforcement seized the phone, and another judge in this district granted a warrant to search the defendant's phone. Accordingly, the phone is lawfully in federal custody, and there is no theft. So you guys, maybe you want to take a screenshot. It's that last paragraph. So it's crazy because they said I risked. Why are you even saying I was risked? So what? Yeah, no shit, I risked being found in contempt, but I wasn't found in contempt. You jumped up and snatched my phone, and none of the court security did, and I wasn't held in contempt. And you took my phone and you went end around to some other judge and supposedly got a warrant. So I haven't gotten anything, and this is where I'm going to start to speculate. I haven't gotten anything in the mail yet regarding that. I did just get this today. I also have not gotten court dates for the disorderly conducts, the 2 disorderly conducts. So there's 2 ways this can go down. They send me a summons, get me a summons, find me, serve me, however they do that, right? And have me come before a judge, and then the judge would order me to open the phone, and I would say no, and they would put me in jail, and we would go down that road, and I would fight it from jail, habeas corpus, and all that stuff. Or possibly they try to get an arrest warrant, or do get an arrest warrant, and then they pick me up wherever I may be, get a freaking tank and break somebody's door down or something, destroy some people's property over me exercising First Amendment protected activity. So that's how I see the 2 ways of this going down. But what do you guys think? What's going on in the chat? I'll check it out. I won't keep this too long. I did just want to update you guys on all that. William Holcomb, what's up? Lisa Johnson, thank you so much. Smokezilla, Buzz. They're trying to baffle you with bull. Exactly. That's exactly what they try to baffle you with bull. And you know, this is going to be a Supreme Court case one way or the other, because they want to jail me over this shit. Let's get it going on, because that was the whole point of it all, right? Our guy, Jim McNevin, what's up? Joko, Kansas City, what is that? Kansas Cop Watch. What's happening? So, yeah, Doormaster. That's it. So I'm going to file, or I'm going to write a response to this and file it first thing Monday. And it's funny because I've been in these situations before, and the judge will rule on it before you even file anything. So we'll see if it's different here in the federal court, or if they pull that maneuver again, or if they'll give me time to respond to this objection. So an epic saga. I appreciate you guys sharing my stuff, getting a lot of shares and stuff like that. There's been a nice uptick in the analytics and all that. And so please share, especially this situation in this video, and join the group, join the Lion's Den, get some friends to join up in there. You know what I mean? It's like buying me a coffee once a month, and you get access to my knowledge. I have no problem trying to help people out with legal stuff, and we got Bear in there. He's unbelievable. Bear Arms, and a lot of good friends of mine are in there, trusted people. So it's the hardcore of the hardcore. If you want to get more involved, go there, sign up for the Lion's Den down in the comments. So hope you all have a good weekend. It's a beautiful day here today, and yeah, take it easy.